Good morning, everyone, and welcome to our webinar today. We will be talking about the impacts of changes to work arrangements because of COVID, and that will be from an employment and an immigration point of view. For those of you who don't know me, my name is Lillian Ajuria. I'm a partner at Ajuria Lawyers. Before we start, I would like to acknowledge the traditional owners of the land on which we meet today, the Gadigal people of the Eora Nation, and recognise the continued connection to land, waters, culture, and pay our respects to the elders past, present and emerging. Our webinar today will take about an hour. We've got a presentation and then we're going to have a chat. You all have a Q&A function, which I'm very sure you're familiar with. So please feel free to pop your questions in there. We've got about 300 plus attendants from Australia and from overseas. So hopefully we will have a chance to get to all of your questions. If not, we'll touch base with you after the webinar. We've got two experts presenting in their fields, and for those of you who don't know them, we've got Lewis Izzo, who's the partner and managing director of the Sydney Workplace Practice at Australian Business Lawyers and Advisors. We at Ajuria Lawyers work very closely with the ABLA with some of our clients, and whilst there's a lot of crossover between immigration and employment law, both areas are very, very specialised. Also presenting today, we have Ron Kessels, another partner at Ajuria Lawyers. And we have two experienced lawyers who will be helping us with the Q&A functionality. Jordan Lambardelli, an associate from ABLA, and Karen Pearson, a senior associate from Ajuria Lawyers. So what we will do today, we're going to cover the different types of work variations that occurred during the changes during COVID and how they're being treated from an immigration and an employment perspective. And then we're going to talk to you about how you can manage some risk and make sure that you're compliant. But I'll pass it to Lewis now to take us from here.
Thanks, Lillian, and thanks everyone for joining us. So I think we're kicking off with the slides. I'm just waiting. Oh, here we go. There we go. So we're kicking off to open the discussion to really focus on the types of different varied working arrangements that have taken place this year. Over the course of 2020. And we want to look at how each of these different types of variations, if I can call them that, have really got impacts from both an employment perspective and an immigration law perspective. And we want to look at the types of things that employers can and can't do in these spaces, but also the types of consequences that might arise if you get these types of changes wrong. So the types of issues that we've seen arise, in no particular order, we obviously have seen an increase in redundancies over the past kind of 6 months or so, and stand downs, marked increase in stand downs, that is people being told not to present for work because there is no useful work for them to do. We've seen the use of leave without pay, so that is people again staying employed, but being asked to take a period where they won't have any payment in order to benefit the financial position of the employer. We've seen changes to hours of work and remuneration, both consensual and in some cases directed. And naturally the consequences of whether it's consensual or directed can be quite significant. Changes to roles and duties and changes to location of work. And each of these types of topics, with each of these types of things that you do, that they're going to have consequences in both the employment space and the immigration space, which is why it's really great that we have the expertise from both firms coming together. So they're the kind of changes we're going to tackle in the next 45 minutes or so. I think to the extent that anyone has any questions, please post them, and I understand that they're going to get processed, but we're also going to leave some time at the end for us to answer them as well. If we talk about these types of variations and why it's worth spending time on this today, there really are things you need to think about on the employment side and immigration side, and I'll certainly deal with the employment side. If you get it wrong, you may well be looking at breach of contract claims, and that might resonate in kind of compensation orders or employees talking about the fact that your conduct has actually had the effect of tearing up the contract, and we'll talk a bit about that. You can definitely be exposed to underpayment claims, which also might resonate in compensation or fines. Constructive dismissal claims or unfair dismissal claims. And again, that's something going along the lines of if the change you've made is so drastic, the employer might say, even if you still want me there, by your conduct, you've repudiated the contract of employment, you've effectively torn it up, and I'm going to sue you for the damages I've suffered. And the last one is redundancy claims. And so they're the main types of areas where we're seeing particular risks arise, or particular difficult or particularly kind of expensive consequences for employers. And what we want to spend the next hour doing is exploring how you can navigate these changes without ending up with those types of consequences. So that's the employment side. I'll leave it to others to talk with expertise about immigration, because that's not my area.
Yeah, thanks, Lewis. So hi, everyone. Ron Kessel's here. It's great of you all to be able to join today, and hopefully you'll get some valuable information from us. Just I guess to put a little bit of context to the immigration area, the Minister Tudge was pretty quick after the first shutdown announcement in March to give a bit of an indication, well, of two things. Firstly, broadly, that temporary workers, if they didn't have meaningful work, and included students and working holiday makers, should basically leave. So that was the first kind of message. And the second message was that if you're staying, we will not, necessarily take action against you or the employer if you're temporarily stood down or you're affected by COVID. So that was kind of the starting point in March. Despite that announcement, we then didn't really have any solid regulations or guidance from government until actually just last week in relation to some of the areas of how this would actually be applied in practice. As a firm, we are regularly in contact with Canberra. We obviously have great relationships with policy and other areas, so we're sort of always onto them through this period. We've managed to eke out bits of information. And so what we'll present to you today is everything that we know as it currently is. There are some areas, though, that are still a little bit up in the air, although they've kind of narrowed. The second thing that I just wanted to make as a sort of a high-level point is that primarily here we'll be talking about sponsored workers and not just general temporary visa holders such as working holiday makers or students. The reason for that is that for employers, by and large, most of the issues come in relation to formal sponsorship and sponsored workers, generally under the TSS program. So we'll be focused on that. But just as a comment, employers need to kind of just watch out that at the moment, there's a lot of people around who are visa holders who have not been able to leave. They may have extended, or they may be working sort of in breach of visa conditions if they're working holiday makers. So you need to really make sure that whatever checks that you've got in place in relation to just visa status, that they're being really implemented and checked within the business, because it is a time of kind of risk. And there is no general concession by government saying, hey, if you employ someone in breach, you're kind of okay. The one thing that they have maintained since the beginning of COVID is that visa conditions must be stuck to, and partly that was driven by making sure that any jobs that were out there would go to Australians. So they're very tight on making sure people are complying. So just a couple of comments there. In relation to the actual impact or the risks that you face potentially as a result of some of the changes that Lewis has already outlined. Well, firstly, there's a possibility of visa refusal. We're seeing quite a large number of requests for further information, or what we call RFIs. So essentially government saying, look, why is it that you really need this person? If you've reduced hours in the business, how is it that you're saying you need additional workers from overseas? So they're sort of testing that issue. There's also then, of real concern is just that you accidentally fall into, or not accidentally, fall into breach of your employer obligations if you're sort of if you've varied conditions outside of what's allowed, and we'll go through basically what is allowed and what's not. For the individuals, there's the possibility of visa cancellation and a forced sort of removal. And then of a lot of concern to a lot of temporary visa holders is, well, what's the impact of changes that have occurred to my employment? What's the impact on my pathway to permanent residence? And fortunately, that is an area that we have had some clarity on just in the last week. So this is a timely kind of webinar because we can actually share some current and useful information on that. So I think if we just, Lewis, take the first issue of redundancies.
Yeah, so redundancies and stand downs, and I might start with stand downs. This is a phenomenon that wasn't very common pre-March 2020. We used to see stand downs occur predominantly where there was a breakdown in machinery or where there was a form of industrial action that meant work couldn't be performed. And in those circumstances, if someone couldn't be usefully employed because of the machine breaks down or because of industrial action, you had a right under the Fair Work Act to tell employers, well, we can't employ you for today or for the next week, or in extreme cases, even a longer period, because you can't usefully be employed during this period. It's not for a cause the employer's responsible for, it's because of matters out of our own hands. Very rare, in fact, pretty much never have we seen stand downs implemented in responses to reduction in custom or downturn of revenue. That was traditionally seen more as something in the realm of redundancy, something that was more in the realm of, well, that's an operational decision to no longer employ particular workers. But that all changed with the introduction of COVID, or the arrival of COVID in Australia, because what we saw was in whole industries, work drying up almost overnight, and the relevant tests for stand down being met, or at least employers arguing that they'd been met. And take the airline industry, that's a good example. What they were able to demonstrate is that there had been a stoppage of work in large parts. So planes weren't flying, cafes weren't operating in the airport terminals, other airport services weren't operating, baggage services, etc. And that was for a cause that the employer couldn't reasonably be held responsible for, namely the COVID-19 pandemic and government measures associated with that. And so we saw large-scale stand downs, and those stand downs were looked at and tested in the federal court recently, particularly with respect to, say, Qantas and Jetstar. And that was a pretty good example for employers because, as you can imagine, the airline industry was particularly heavily hit. And what the court said when it looked at this was, well, an employer decision to stand down a worker, that won't necessarily give rise to an ability to stand down if you've decided to shut your business or you've decided to stop trading. What you need is that to be the natural and probable consequence of some external influence or factor. And the court was satisfied in the case of Qantas and Jetstar that the COVID-19 pandemic was an external factor, the natural and probable consequence of which is that there was a stoppage of work for large numbers of employees. Now, when you take it out of airlines and you start to talk about retail, hospitality, things like that, again, employers need to be conscious, both before COVID and now, that if you are talking about standing down employees without pay, you still need to meet those fundamental tests. Is there a stoppage of work? So that's not a downturn. Is there almost a complete stoppage of various activities? Is that for a reason you can't be held responsible? So if you're in a shop and that shopping, say it's in a shopping centre and you usually get trade of 1,000 people through the shopping centre in a day, and now that's dwindled down to 100, and there's still the odd person coming to the store, I'm not sure there's necessarily a stoppage of work for the sales assistant. But if, on the other hand, it trickles right down to 1 or 2 people entering the shopping centre because of government measures or inabilities to get to the shopping centre or whatever, then you're probably looking at a drastic enough deterioration in custom that a whole scale number of work activities are stopping. Selling, any stock filling of shelves, any other kind of security, all that stuff may or may no longer be required. and you might reach the relevant threshold. So the first thing is employers need to be conscious that they can't stand down without meeting that requirement. As a result of COVID, though, we do have now the JobKeeper laws. And for those employers that are accessing JobKeeper, you'll probably be well aware that you can stand people down if they are in receipt of JobKeeper payments. And there's just two very key requirements that you need to be conscious of and that I might refresh your memory on. And that is, you still need to establish that, that the person cannot usefully be employed during the period they're being stood down, and the stand down needs to be reasonable in all the circumstances. So even if you're in receipt of JobKeeper payments, you need to ensure that you are meeting those two threshold hurdles. But provided you are, you then have quite significant flexibility to stand employees down, and you will probably be able to stand down employees on JobKeeper all the way through till March 2021. So that's a very new flexibility that employers have been able to access. And the final point I'll make on this is, if you don't meet those relevant threshold requirements, you do have significant headaches. Because if all of a sudden you are saying to people, I no longer have work for you, I'm not providing you with payment, and you don't have a right to do that, there's a couple of consequences. One, you're probably looking at breach of contract. Two, you may well have employees say it's a constructive dismissal or a redundancy. That is, employer, you have no work for me. You're not providing me with any duties, anything to do. That's something you're obliged to do under my contract. Accordingly, you've repudiated the contract, and that's because you no longer need my job to be performed by anyone. And that's kind of a classic redundancy scenario. So you need to be ensuring that if you are looking at standing people down, you're following the appropriate process. The other thing I'll say quickly on redundancies, if you are implementing redundancies for all employers, and this applies pre-COVID as much as it applies now, there are 3 prerequisites you need to meet in order to exempt yourself from unfair dismissal laws. And they are: 1, the job the employee is performing must no longer be required by anyone. And so the classic example for that, and it's funny I still have to say it, but you do, that means you can't hire someone to replace someone you've just made redundant, because ordinarily the job's no longer there. So usually you should be seeing your headcount go down. So number 1, you no longer need the job done. Number 2, you've complied with all consultation requirements in any award or enterprise agreement that applies to the worker before making them redundant. And just bear in mind that those consultation obligations can be quite prescriptive in awards. And 3, you've exhausted all possible redeployment opportunities in relation to the employee. That is, it wasn't reasonable to redeploy them elsewhere within the business. Now, if you've complied with all 3 of those, then you'll actually have quite a smooth redundancy process. And even if a claim is brought, a good basis to defend it. If you miss any one of them, then you're probably going to be liable.
That's Lewis, just a quick question that's come up on that. Have you seen an increase in unfair dismissal claims coming on board since COVID? Have you seen the numbers change?
Yeah, the commission unfair dismissal numbers have increased by about 25%. And I think that's a byproduct of 2 issues. One, there's probably more people being made redundant, and that's generating the increased claims. But I think we're also seeing more people contest redundancies because they have less options available to them in terms of alternate work. We know unemployment's obviously higher now. And so they're more likely to cling on to this notion of, I want my job back, or I want some compensation because I'm not going to get a job easily. So the short answer is yes, though.
Interesting. Thank you.
Over to you, Ron.
Thanks, Lewis. So again, just before we get into sort of the nitty gritty, a couple of higher level points. The first is, we're often asked, look, are there any special rules that relate to temporary visa holders about redundancies or stand downs? And the short answer is really no. I think as a practical, and our advisors generally, speak to Lewis, but generally treat them the same as Australians. As a practical matter, what we saw during COVID was a reluctance perhaps, or an attempt by some employers to sort of hang on to temporary workers because they'd actually spent quite a lot of money in bringing them over or sponsoring, and they were not entitled to any sort of JobKeeper allowances, etc. So really, without any work, a lot of people were choosing to leave or being put in a position where they needed to leave. So we were sort of on a practical level, perhaps some differences about how workforces were treated, but at a legal level, there's not. The second thing is that at a corporate level now, the consequence of having made redundancies or having stood people down is sort of flowing through to either pending or new applications to sponsor or renew temporary workers, because the question that the department is asking is obviously, well, if you've made people redundant or you've got a whole bunch of workers stood down, why is it that you need to sponsor someone? So that at that level, it is actually having a very practical consequence for companies who have had redundancies or stand downs. At the individual level, a sponsored worker, depending on what visa they're on, they either have 60 or 90 days to find a new employer. So this is if you've been made redundant, lodge some other sort of visa application or depart. What is a common sort of misunderstanding is, well, what happens when you hit that 60 or 90 day mark? It is not the case that on that 60 or 90 days, the person's visa sort of magically disappears and they're just not, they don't have a visa anymore. The department actually has to go through an entire cancellation process. So they would need to locate that person, write to them, say, hey, we understand you've lost your job. So this is after the employer has notified of the job loss. And they then have a chance to say, well, look, don't cancel my visa for X, Y, and Z reason. So as a result of COVID, there hasn't been a sort of a lot of cancellation action for people who are in Australia because they don't want a bunch of illegal people. So the department has been encouraging people to make some sort of alternative visa application, like even a visitor's visa or a sort of a COVID visa that they created to bridge them over until they can depart. So you will find as employers, there's a bunch of people, as I sort of alluded to this at the beginning, there's a bunch of potential employees out there who are going to be in this weird and wonderful situations where they've kind of either left jobs or they've been made redundant, they have visas, they haven't yet been cancelled, they're beyond their 60 days, so they're not strictly complying with the terms of the visa, but then again, they really can't because they can't depart. And so what we are seeing is a real increase in queries about how do we deal with and can we make offers of employment to people in all these various situations, and then are we going to be able to sponsor them or extend their visas or what's going to happen? So that's created quite a large population of people in the country who are potentially able to work or to be sponsored, but are in sort of, in this transit sort of position. So if you have those, just obviously give us a call. But so that's one thing. The second is that, as I said, Minister Tudge in March made it really clear that, hey, look, if people are temporarily stood down, that won't lead to or should not lead to visa cancellation because, they understood that those workers were potentially going to be needed back for the recovery. So essentially what they said is, look, if you temporarily stood down, not if you've been made redundant, but if you've temporarily stood down, we'll kind of let you sit and then see how things go, as the business opens up again. That left people in this kind of bit awkward position in relation to their pathway to permanent residency, which is obviously on the front of mind for a lot of sponsored workers. Which depends on you having actually worked for certain periods of time if you're using a transitional pathway from a temporary visa to a permanent visa. But on the 24th of November, finally, after, as I said, months and months of everybody asking and lots of high-level meetings, government finally announced that, yes, look, they passed some regulations to say that the period of a temporary stand down due to COVID would be treated as if the person was still employed for the purposes of the permanent residence application, so people aren't going to lose time. So that's kind of that's a good thing, and it's settled a lot of people's minds, and it means that from a practical point of view, a lot of applications which were basically on hold, or we were advising people to hold off because we just didn't know how they were going to be dealt with, they can all sort of go forward now. So if you've got people that have been sort of chomping at the bit to do their permanent residence visa, but it's been sort of held because nobody was sure what government was doing, that's now been clarified.
And just on that point, Ron, interestingly, we actually haven't seen a lot of cancellations or visa refusals during this period. At the beginning, we were a little bit nervous with what government would do, whether they would start refusing. And the answers we got back is that no, they're not making decisions because they don't want to clog up the tribunal with appeals. So there hasn't been a change in pattern. I think the Department for Immigration is really holding off a little bit to see how things settle down. And certainly with the request that we're getting for further information, it's all about whether people have been stood down or they've been made redundant.
Yeah, they're certainly differentiating between those two things. I think there'll be a lot of people who have been made redundant who are potentially going to be re-employed somewhere. So that'll be in those first points. So Lewis, back to you on leave.
Yeah, so leave's been it's been a big lever that employers have been able to pull to try and address their declining profitability and to try and stay afloat. Because as our viewers will know, annual leave in particular is something, it's a liability that employers accrue. So it's sitting somewhere on a balance sheet. And if you can access that and put people on leave, then you don't have to pay out wages. You're actually paying out leave you've already previously accrued. Before our onset of the pandemic, if I can call it that, the right to direct the taking of leave was constrained, somewhat constrained. And if you're going to direct an employee to take annual leave, you had to first ascertain whether the employee is covered by an award or enterprise agreement, or if they're award EA free. If they're covered by an award or enterprise agreement, you can only direct them to take annual leave if the award or EA allows you to direct them to take annual leave, and you have to do it in accordance with the terms of that instrument. So particularly if you're on an enterprise agreement, you need to have ensured that you've negotiated an ability to direct leave to be taken into your instrument, or otherwise you're looking at the award provisions, which again are sadly somewhat complex. And so to actually direct the taking of leave, you either need, in many awards, to either have some kind of close down provision that you have to comply with, or if it's excessive leave, there's a very rigid regime you need to go through. For award-free employees or EA-free employees, you can direct any employee to take leave at any time, provided the direction's reasonable. And so that's kind of a much broader framework that's allowed, and provided you could set out a reasonable basis. And it's usually, when we look at reasonableness, it's did they get a fair and adequate period of notice? Is there a legitimate basis behind it, operational basis behind the leave being directed? And also looking at the individual personal circumstances of the employee concerned. But provided you look at those matters, then really there is an at-large ability to direct taking of leave for that category of worker. Since the introduction of, or since the response to the COVID-19 pandemic, there's been a couple of flexibilities allowed in relation to leave. For those viewers who are engaging clerical workers, a new schedule's been introduced into the Clerks Award, and our firm actually acted for the Australian Chamber in order to have that schedule inserted, and we've had a number of contested proceedings about that. But this schedule gives employers a much broader ability to direct the taking of leave. It's relatively unfettered, although there is an overarching reasonableness requirement. And you can avail yourselves of that for clerical employees. For those employers on JobKeeper, you may have recalled that the JobKeeper legislation provided that if you've got employees receiving JobKeeper, not only can you stand them down but without pay, but alternatively, you could direct them take leave. Or sorry, I should take that back. You could request that they take leave, and they could only refuse that request if there were reasonable grounds to refuse. So provided the request was not unreasonable, they had to take the leave. Now, that actual provision's been stripped out of the JobKeeper legislation, so it's no longer available for employers, but we still do have the award provisions. So again, clerical workers, and there's a range of other awards that still have ability to direct the taking of leave in there, but they won't be as flexible as what we've now been able to secure in the Clerks Award. So I think for employers in this space, many of you may have already used this if you really were in a position of distress, and that's certainly our experience. A lot of employers look to use this direction ability early on, but some of you might be looking at the Christmas period coming up and thinking, well, this is a really important time to actually try and reduce some strain on the business if you're not back to 100%. And what I would say, if that's the case, in order of importance, 1, check your instrument. 2, absolutely the more notice you give, the better. Not only because that allows employees to plan and prepare, but it will help you pass that reasonableness test that's necessary in both the Clerks Award schedule, but also award agreement-free employees. And 3, if you're not permitted by your instrument to direct the taking of leave, well, then you're going to need to think about other things. Can you go to your employees and get their consent to do so? Or failing that, you need to be very careful because otherwise you may be in breach of the Fair Work Act. So they're the things you need to be thinking about in terms of taking of annual leave, which is really the big ticket issue when it comes to the pandemic. I'll say one other thing before I hand over to Ron is, in some very discrete areas, there are new forms of leave coming up. For those people in Victoria, there's a new form of casual leave that's been made available to casuals that's paid for out of the Victorian government's purse. There's also in the social home care disability services sector, a form of paid pandemic leave that's been made available, and a couple of the other health sector awards as well. So if you are in a sector that's got frontline workers dealing with the COVID-19 pandemic, just be conscious that there's a form of paid pandemic leave being made available as well, which is a new form of leave.
Thanks, Lewis. So look, we can be relatively brief on the immigration side with this. This is an area where I'll come to the permanent residency, but on the temporary visa holders, there really hasn't been any change formally to the existing policy, which is that as a general rule, temporary workers shouldn't really be taking leave without pay for periods in excess of 3 months, unless there's some sort of like exceptional circumstances or there's an obligation to provide leave under Australian workplace laws. So that just fits with the general purpose of temporary visas, which is that, people are here temporarily to work and generally not to just go on leave without pay. What I think as a practical matter, however, we have not seen or heard of any sort of cancellation or enforcement proceedings against anybody where there has been an agreement because of COVID to use leave without pay. We don't believe that there would be, or that you'd at least have a very strong sort of argument. It's probably more likely that the policy just hasn't sort of caught up with itself, or they, they are still trying to ensure that the message to employers is, look, as it was back in March, if there's no work for a temporary worker, then generally speaking, they should go home. But basically, if you're complying with employment law and you're doing it because of COVID, it should be okay. In relation to permanent residency, this was specifically addressed in the recent legislation on 24th of November, which basically says that as with temporary stand downs, if you're on a period of leave without pay, that will be counted towards your permanent residence time. Lewis, back to you on hours.
Yeah, so if you put any right to direct reduced hours or salaries aside to one moment, one of the things that we saw both in the aftermath of the global financial crisis and the immediate aftermath of COVID-19 was straight away, there were a number of employers who said, oh, if I can't do something immediately, or if I can't do something now, either lots of people are going to lose their jobs or the whole business is going to just shut up shop. And so what employers we saw do in particularly distressed industries is they simply went to their staff and said, I really need employees. I'm asking you, imploring you to please agree to some varied working arrangement. And often that involved full-time workers going down to reduced part-time working arrangements. Might have been a 25% cut in hours, might have been a 40% cut in hours. And this applied in the aftermath of COVID across all sorts of employers. We saw big four accounting firms do this, we saw law firms do this, we saw hospitality employers. And the fundamental element of this particular variation is if you say to your employees, and you need to be careful you don't make any implied threat here, but if you say the business is in dire financial distress, we need your help, will you agree to reduce your hours? And they agree voluntarily to change their employment status or reduce their hours, then that is entirely lawful. And you can, in fact, achieve a level of relief by having employees consent to either lower working hours or lower salaries potentially. And we saw a lot of that. Now, obviously, you want to document that in writing. The number one word of caution to employers who have done that or who are perhaps still thinking of doing that is that you need to ensure very carefully that there's no implied threats there. So you can't say, if you don't agree to this reduction, I will make you redundant. Or if you don't agree, I'm going to do some other adverse thing to this group of people. You need to ensure that you appropriately spell out the dire financial position you are in, and then effectively you are requesting the employees and hoping that they join the dots and make it work out 2 and 2 makes 4. And the reality is if they don't do this, the company or their roles might not survive. Now, if you do that, you can actually, by consent, vary people's positions, their duties, their salaries, or their working hours. And a lot of this was done. You can't do it unilaterally though. And this point was made clear in a decision involving Broadlex earlier this year, which is an employer that had a cleaner. And about 5 years ago or so, they went to a cleaner who had a full-time role and said, look, clients change their needs. We're reducing your hours by 40%. The cleaner said, I'm not happy with that. I don't agree. They gave the cleaner a new contract, which said your hours are now 40% reduced. But the cleaner made it very clear that she did not consent to this new arrangement, but she kept working the part-time hours. A number of years later, the United Voice brought a claim on her behalf against the employer, saying she was actually made redundant when you reduced her hours because she had a full-time role. You terminated that role and that employment because you no longer needed it, and then you started employing her part-time. But at that point in time, a redundancy event crystallized, and you should have paid her out a redundancy. And the employer contested that and actually lost. And the federal court found that when the cleaner had her hours so drastically reduced, there was effectively a tearing up of the contract of employment at that point in time. And so the employer was made to pay out this employee, even though she remained employed for a number of years thereafter. So that's the risk that arises if you unilaterally do these types of things. Naturally, again, for those employers who've had the benefit of JobKeeper, you have an ability to reduce hours for those employees receiving JobKeeper payments. But importantly, and this is a real point of distinction that people need to take note of, is if you've reduced someone's hours during JobKeeper, when those measures expire in March next year, they will automatically revert back to their pre-JobKeeper hours of work. Your right to have reduced the hours will effectively slingshot back. That's not the case for employees who agreed to reductions to their hours or variations to their role by consent. Anyone who consented to a reduction has effectively consented, depending on the terms that you agreed, but may well have consented to a variation on an ongoing basis. That is a permanent change. And so if they want to now change it back, they would need your consent as an employer before changing back. Whereas that's not the case with JobKeeper. If you've issued a JobKeeper direction, it ultimately dissipates and into thin air once the laws end in March 2021.
Sorry, Lewis.
No, that's where.
No, look, on that point, we have a good question here. Is that someone who the employer doesn't meet the JobKeeper for the January-March period, but they don't have the work in January, so they want to be able to pay 60% of the wages for January. So what happens in that case?
So in that case, the employer really only has two options. One, they come to some consensual arrangement with the employee that the employer is willing to agree to. Or two, if the employee won't agree, then you may well have to make the employer redundant. And they're the only, because otherwise you're bound to honour the employee's former employment contractual arrangements.
Thank you. Over to you, Ron.
Okay, great. So this does have some immigration implications here, hours and salaries. The first thing is the reduction of hours. It has been made pretty clear by the department and the minister that a reduction of hours with a prorated reduction of salary will be okay, as far as like it will not lead to sanction or visa cancellation if they're the result of COVID, obviously. So if hours had to be reduced or were agreed to be reduced, or they were reduced under a JobKeeper arrangement that applied to the Australians and then that cross-applied to the TSS visa holders, then from an immigration perspective, that's all right. I think, Lewis, may be an interesting question, which is that, strictly speaking, the TSS visa holders, to my knowledge, are not covered by JobKeeper directions. So presumably from what you've just said, if they didn't agree to a reduction in hours, then it may be that they were just, there was no role for them. So I don't know exactly kind of how that's all being dealt with on the employment law level for any temporary visa holders, but from an immigration perspective, that's okay. If there, and you might want to comment on that when we come back. The thing is, though, that if there's a reduction of actual salary for the same number of hours, in other words, it's not a prorated reduction, then that does require a new nomination. So if you just ask people to take a 20% reduction in salary, then strictly a new nomination needed to be lodged, and there hasn't been any formal announcement of any exception to that rule. We don't know exactly how that will be dealt with if in fact it has occurred, and I think it's one of those ones we're going to have to argue out afterwards, because most employers were not in a position to just go and lodge new nominations with training levies and everything else to reduce salaries. They had to reduce the salary because they couldn't afford to pay it in the first place. So I think that's going to be one for a wait and see and a fight. And then in relation to the big question for permanent resident applicants, that law that was introduced has also said that if hours were reduced under COVID, then the person will be treated as having been working full time during that period. And for those very few people that are relying on an age exemption for permanent residents, because they're over 45, but they are on a high income, they're above the high income threshold salary, then the law also allowed for a temporary sort of reduction of salary. If salary was permitted to be reduced and it reduced below the high income threshold, then that would be okay as well. So that's basically the summary of hours and salary. So essentially it should be okay. The ones that are kind of potentially problematic is where there's just been a pure reduction of salary that wasn't matched with a reduction in hours.
Yeah, and Ron, just on that, JobKeeper is only available to permanent residents, citizens, and New Zealand people on New Zealand visas. I think there might be a special category visa for the Kiwis. Other than that, it's not available. So you're right. If there was a reduction, it should have been done by consent. Roles and duties, I'll be very quick on this one because I think it's broadly been covered by what we've said before. So again, generally contractually, that instrument will govern whether you can change someone's roles or duties. Just with duties, most contracts these days do allow a level of latitude to give people different duties from time to time, but you need to ensure any change you're making is consistent with the contract terms. Does the contract contemplate elements of the duties changing at the employer's direction. If it doesn't, you might have a problem in terms of breach or even redundancy if it's a significant change to the role. Again, that doesn't apply for JobKeeper, because under the JobKeeper reforms, you do have the ability to direct changes to roles and duties, provided it's reasonable in the circumstances. The only other thing I'll say on this one is that we are likely to see some industrial reform in the coming weeks. We're hearing a lot from Christian Porter about some new measures coming in, and they might have ongoing greater flexibility about tinkering with duties and roles, and we'll have to see what that looks like. But this probably isn't as big a one, and given the time, I might flick it over to you, Ron.
Yeah, thanks, Lewis. And so here the rules are pretty simple. You really, and this hasn't been changed due to COVID. A sponsored worker is not allowed to change occupation or employer, for that matter, without a new nomination. So if a change in duties was so significant that they in fact ended up doing a different job, then that was not permitted and it would be seen as a breach. The second is that there is, within an occupation, there's some ability to vary duties, and that may be arguable, but there is still a requirement to notify of those changes. And the reason that that's there is that they want to make sure that it's not affecting market rate. So even though you're within the same occupation, that you're suddenly at a lower level or that you're at a higher level, and there should have been some market rate adjustment. So some variation is okay. And if you varied slightly, we'll talk to you about the relative sort of risks of notification, non-notification, etc. And a lot of this is a little bit of a grey area, but that's the basic rule. It's really pretty unclear how, if a person has been effectively doing something else or not quite doing the role during the period, whether that could affect a permanent residence application. It's obviously going to become a question of fact, and how does the department find this out, and et cetera, and what it was and the extent to which it was. But it could be the case that there's a small population of people who are kind of in a worse position because they basically ended up doing something different to what they were sponsored to do. And whereas if they'd just been stood down or been on leave without pay, they would have been caught by that new rule, which would have given them a concession. The fact that they've still worked might put them in a worse position, but we think this will be a pretty rare situation. If that's sounding to you like, oh, that's something, that I have to think about because X and Y, that their job was changed somewhat, then I think just give us a call. And this is one that we really would have to do sort of on a case by case basis. Perhaps before you start, Lewis, I think there's been a couple of questions on people overseas. And so I'll leave it to you to start, but just from an immigration perspective, one of the things that's happened is, of course, visas either have not been approved or they have been approved, but people haven't been able to travel, or people were here in Australia and then departed, but haven't been able to get back. And we get this quite a lot with employers asking sort of a double-barreled question from an immigration point of view and from an employment law point of view. Is there any issue with this? And I think, Lewis, we've spoken about, what's the situation if people are, suddenly overseas, or they're, put on suddenly as contractors, etc. So I just float that. I mean, maybe on this one I can start just to answer that from an immigration perspective in relation to that question. There's been broadly a concession. They understand that some people have not been able to get back. If visas have expired while people have been overseas, then they do still need to apply for a new visa. There's some talk about some extensions and things in relation, some concessions in relation to fees and things like that, but they need a new visa. If they've currently got their visa, but they just haven't been able to travel and they are working overseas, well, from an immigration point of view, they don't care where you're working, quite frankly. If you're working overseas, that's fine from a visa perspective. But Lewis, I don't know whether you wanted to just jump in there from an employment point of view.
Oh, look, the thing about location of work, it's not really a big issue for us when an employee and an employer consensually agree to a different spot. The real issue here is if an employer unilaterally starts changing the location of work. Now, generally, most employment contracts will specify a place of work. Enterprise agreements may do that as well. And if you change the location of work in such a way that it materially impacts upon the employment relationship, the employee's ability to attend for work, in such a way that it's kind of beyond the bounds of the contract that was executed, you may have a trigger for a redundancy event. So it's the same thing. You change someone's salary materially, you change their hours materially, their duties materially, or even their location. If it's quite a substantial change that's not contemplated by the contract, it could well give rise to a claim for redundancy. And what the courts and commissions will also look at is the degree of increased distance to travel. They'll be a lot less concerned about someone moving to a building 3 doors down than they will to someone moving a new 45-minute car trip away. And so that's something employers need to bear in mind. The JobKeeper provisions do allow for changes in location to be made at the employer's direction. So it's different in the case of JobKeeper. It doesn't matter what the contract says. You can actually mandate a change in location, but it needs to be reasonable in the circumstances. And again, I mean, with the JobKeeper provisions, it's only for employers on JobKeeper and it's only till March. What I haven't dealt with here, because we'd need an entire new webinar or webcast on it, is working from home, which is a big shift in location that's happened by necessity. That's broadly gone off without a hitch in terms of not being any contractual breaches with employees moving to home-based working. We're seeing a lot of tensions now in relation to some employers wanting to bring employees back, employers not necessarily wanting to come back full-time or part-time. And that's an area where we're going to continue to update clients on with alerts and webcasts, etc., because it's going to be a really hot topic over the next 3 or 4 months. But yeah, in terms of actually someone's physical location, in terms of the workplace, just need to ensure that the transition is something that's within the boundaries of the contract. And one of the other things to think about is maybe look at your contract drafting. We should be ensuring that you have a flexibility there, that it's not limited to one specific place, but perhaps a broader area which is reasonable in the circumstances.
Yeah, I think, thanks, Lewis. I think other than the people overseas that we've kind of dealt with in relation to that, the only other thing, and I'm not sure how broadly this applies, but if there's been a change in work location, even a mandated one under JobKeeper, depending on where that change has been made to, employers would still need to look at market rate for that particular new location. Because market rate is often a location-based thing. So hypothetically, if you were moved from Brisbane to Sydney and salary needed to increase as a result, then that would have need to be looked at. But I think that that's really going to be extremely rare and probably not anything of great concern to most people. So it's really just people stuck overseas. And as I said, there seems to be some general concessions that they're not cancelling people as a result of the fact that they can't come back, provided employers are saying the jobs are still available. And then as to whether they can work from an immigration perspective, it's not really an issue. So I think sort of that's before the questions, Lewis, this is kind of the wrap up here.
Yeah, so, I mean, what are we seeing? As I said, there has been an increase in unfair dismissal claims. There's also been a number of JobKeeper disputes. So those employers that are using the JobKeeper flexibilities, if they overstep the mark, we're seeing claims filed in the commission. They're being dealt with very expeditiously. The members are not afraid to issue orders quite promptly in relation to the JobKeeper disputes. So employers do need to ensure they stay within the rules there. In terms of the regulator, the Fair Work Ombudsman, we haven't necessarily seen them going on a hunt to ensure people haven't been doing the wrong thing during COVID. They've been more sticking to their usual area, which is, are people paying the correct wages as per an award? They've ramped up their compliance activities with respect to award and EA compliance markedly. And we've heard all sorts of employers caught up in underpayment scandals, whether that's Coles, whether that's Woolies, whether that's George Columbaris, CBA, every single company seems to have underpayment headaches. So the Ombudsman's busy on them as opposed to looking at specific COVID activities. But that's that's the areas of exposure primarily that we've got up on the screen. In terms of what you can do as an employer, I think it depends what circumstance you're in. If you think you're pushing close to the line, I'd be looking at your contractual arrangements. Do you need to roll out a new suite of contracts that allow you more flexibility with duties, that allow you more flexibility about location of work and things like that, so that you can move more freely in terms of the work allocated? Or on the other hand, if you are really in distress, it's more about ensuring that you're meeting and satisfying the prescriptive regulations that apply, whether it's for directing annual leave, imposing a redundancy. Just make sure you tick off the boxes that need to be ticked, and you'll substantially minimise any compliance headaches. So that's probably what I'd say at a high level for the employment scene.
So for a question for both of you that's coming through is, what sort of, if the ABF or Fair Work came to do a compliance check, how do they carry those checks out? What are we seeing? And maybe comment as well on the data matching abilities between different government departments and how that's transparent, and the Fair Work inspectors' powers under both acts.
I'm happy to jump in. I mean, in terms of the Fair Work Ombudsman, if they do come in, I always have two pieces of advice. Make sure you're cooperative and make sure you're proactive. The Ombudsman takes a much more friendly view of employers that actually look to try and remedy issues. If you make a genuine attempt to remedy breaches that have been identified, they won't prosecute. They prosecute where they think employers are being intentionally underpaying or are being uncooperative, or you take so long to cooperate that they mistake that for non-cooperation. They have very broad powers. Ron will be able to comment on the ABF, but the Ombudsman has a power to issue notices to produce for almost all your documentation. But the final thing is, I've not seen much cooperation or data matching, as it were, between the agencies. They seem to operate very distinctively in a segregated fashion. And just because the ABF turns up and says they might have payment concerns, that doesn't mean the Ombudsman's going to be involved as well. They seem to be running very different races. So that's really the Ombudsman perspective. As I said, just got to make sure if they do identify an issue, you do get onto it quickly, because they otherwise become frustrated, and eventually you hit a snapping point where they move from kind of persuasive compliance to litigation.
Yeah, we're definitely seeing some Australian Border Force activity. It's starting to increase. It was a bit of a hiatus. I mean, essentially there's three sort of ways. They either just turn up, surprise visit. Generally, if they've had some sort of tip-off or they've got some really serious concern, they let you know that they're coming and they book an appointment and they want to come chat. Or just what we're finding at the moment, paper audits, because it's easy for them because they've got a checklist of things that they're looking for, that they're checking off to make sure sponsored workers are being paid, they're working in the role, like they've got an easy enough list, much like the Fair Work officers. And I think they've got crossover powers. Well, I know they have crossover powers, so they can put each other's hats on. That they generally can ask for documents. They can ask to speak to people. If they do a surprise visit, it's not unusual for them to pull a bunch of temporary workers on the side, or even some Australians, and ask them a bunch of questions. So it's fairly intense. Unlike Fair Work, by the sounds of it, Lewis, ABF tend to be not so generous. Although if you're upfront, you clearly have not deliberately breached any rules, then as a general rule, they're pretty good, and they will tend to give you a warning the first time around, depending on the severity. But we have had the odd weird case where, or not weird case, but where they've taken a particularly harsh line and you've ended up with suspensions and fines for things that looked relatively minor. They're very focused at the moment, the ones we've seen, on payment, not surprisingly, because they want to know that everyone's being paid during COVID. And they're also very focused on making sure that people are actually sponsored workers are only doing the job that they've been sponsored for. And I think they've probably been given a bit of a brief there to make sure that Australians are not missing out on jobs by people just basically, using sponsored workers who were sponsored for job A in job B rather than hiring an Australian. So that seems to be their focus at the moment. I think from our perspective, our main focus in all of this area is always to try and get companies accredited. We're definitely seeing a difference in approach towards things like requests for further information, and the level of scrutiny that's going over an application is hugely different for an accredited sponsor as compared to a non-accredited sponsor. So we have always taken the view that accreditation is kind of gold, and that you do everything you can to get it and keep it. So that's paying off now for those employers who are accredited. They're being looked at kind of, as a trusted employer. We are seeing quite a large increase in the number of employers, not necessarily clients, just employers who have either received an ABF letter or are worried about it because it's becoming a bit of an issue. Their own internal compliance checks have kind of fallen apart a little bit during COVID because they just didn't have the people to do the normal checks on visas and work rights and the usual stuff that needs to happen. So we're being asked to do quite a few kind of audits and compliance type pieces, with a view, Lewis, to exactly what you said, which is let's identify anything that has happened. Let's remedy it. We may put our hands up to it early. We may just say, well, if it comes up, at least we can show we remedied the situation. And that will help it on the defence side. So it's definitely now, I think, as the dust is settling on COVID and people are getting back to business, I do think, and that was part of the purpose of this webinar, was that it kind of, I think employers are starting to reflect on, okay, well, what happened, and let's tidy it up if anything's gone wrong.
And just another question for Lois here. If you have a sponsor that is sanctioned by the ABF, one of the problems, apart from a possible fine or bar from sponsoring people, cancellation, things like that, is that the company will actually appear in a public website where you can see sanctioned sponsors. Is there anything similar to that with Fair Work?
Not really. The Fair Work Ombudsman doesn't tend to publicly name and shame until they're really getting close to the prosecution point. And then when they file, they might release a press release about the prosecution. But unlike the ABF, from what Ron's saying, 90% of the people that the Ombudsman talks to, it never goes any further than get your house in order, fix it up, and then we'll let you go. So it's that most employers, if they are proactive and cooperate, it'll never get announced anywhere. The employer will get the underpayment rectified and everyone moves on. It's very rare for prosecutions to be commenced if you're good and responsive when they come knocking.
Yeah. I think we've run out of time. It's 12 o'clock, believe it or not. It's been an hour. I think Jordan and Karen have been doing an amazing job answering all the questions online. So thank you both. And a big thank you to our presenters. That was a fantastic webinar. I even found it really interesting listening to the employment point of view. We at Ajuria Lawyers, we're running these webinars all the time. I know that you guys are running them as well. So if there's any suggestions for more webinars in future, please let us know. And I guess we will take the opportunity to wish everybody the best for the holiday season. It's been a difficult year all around, and we certainly need a break, and I'm sure everybody else does as well. So thank you again for attending. And if you've got any questions that we didn't have a time to get to, please do get in touch with us. And again, thank you.
Thanks a lot.
Thanks very much.
Bye, everyone.
Thanks, everyone.